All right, do we have any counsel that's ready? Who are you ready on? Court call CR 22-345, State of Texas versus Charles Brandon Young. Set today on, I believe. What do we set on? I have evidence. It's GTA. So. What's the reason for resetting? All right. I think we're pretty close to you hear back from her today? Because my concern is you're about to expire off the contract, and when we come back, well, you'll have a new attorney. That's my next contest. It's the end of October. So. All right, court sets Mr. Young September 15th, 1:30. Who else, Mr. Schmidt? Jatavian Darnell Ross, CR 2463. Oh, good. Oh. All right, Mr. Ross is here on the state's motion to revoke.
That's correct, Judge. Similar announcement that I was recently appointed to Mr. Ross, and we'd asked for some more time. We can try that September 15th date as well.
All right, court sets Mr. Ross for hearing on the state's motion September 15th at 1:30. Yes.
Earl Mosley.
Earl Eugene Mosley Jr., CR 25-236. All right, Mr. Mosley set on the state's motion to revoke.
Similar announcement as for September 15th.
All right, court sets Mr. Mosley September 15th at 1:30.
September 15th. Have a plea about it.
Giovanni, are you ready?
Yes, Judge. Owen Stephen Baker.
Cohen Stephen Baker, CR 2694, CR 2695.
Judge is here for arraignment. We're waiving arraignment.
Yeah, let's let him get up here so he can be a part of the hearing. Sorry to interrupt you, Bonnie. Go ahead.
Yeah, we're here for arraignment. We're waiving arraignment, asking for pretrial setting.
Is his name spelled correctly in the indictment?
Yes, we.
Does he understand what he's charged with?
Yes, Judge.
He's entering a plea of not guilty.
Yes, Your Honor.
All right, court finds that Mr. Baker, having waived the formal requirements of arraignment, enters his plea of not guilty into the record, sets his matter for pretrial hearing. Mr. Bondi, if you have your calendar, are you available on September 29th, or October 1st,
October first in the afternoon.
or September 29th. Yes, sir. Either one.
Afternoon.
Yes, yes,
I
sir.
could do, September 29th.
September 29th at 1:30. Very well. Court sets Mr. Baker for pretrial September 29th at 1:30, both cases. But Mr. Bonnie, make sure that you get with the state and get set up for discovery so that you can get what you need.
I fill this date out or?
Yes, sir. You need to fill that out. He needs to sign it. He'll get the yellow copy. White copy will stick in.
Okay, thank you. He's already signed it. Oh, yes, okay.
Want to give him his copy? No.
What's he get? Does he need it? Thank you. Thank you, Greg.
Thank you, Mr. Bonnie. Is that all you have?
All I got.
Thank you, sir.
Excuse
Yes, sir. Your excuse.
to,
Good to see you all as well, Mr. Bonnie.
tomorrow.
That's your call, right? You down here more often?
Always.
Thank you, sir. Be safe. Mr. White, are you ready? Hope so. Gustavo Castillo, CR 22-319.
What are we doing?
Got it.
Yeah.
All right, Mr. Castillo is here on the state's motion to revoke. Any announcements?
Your Honor, the state wind up amending their motion to revoke on the 19th. I still haven't had 10 days, but I didn't actually get that until this afternoon.
Very well. All right, court finding the state's amended its motion, Vince titled more time. Court hereby says Mr. Castillo for final hearing, state's vote on October 29th at 1:30.
Is that October 29th?
October 29th. That's my next evidentiary hearing. And Mr. White, if you and the state reach some kind of agreement, you want to present it to the court, we can set it earlier than that.
Okay.
Just notify Ms. Tabram. But if there's no agreement, then October 29th will be the date I guess.
Okay, thank you, Judge.
Yes, sir. Already told, so we can set it to.
Jermaine, are you ready on any?
For a couple of. Thanks, go ahead and take those up.
Do you have any that are not pleased that are just announcements? Or all of yours resolutions?
No, Judge, let me. We just.
I do have the plea papers on Mr. Hairston. I have that one.
Judge, you also should have some for,
I do not.
okay, well,
That's all that I have.
Ms. Wagner and Mr. Mays as well.
Mr. Hairston, come on up.
Yeah, yes, absolutely.
Where's on record, cause number CR 24 72, State of Texas versus Charles Harrison in the second. Mr. Harrison, if you'll raise your hand, I'm gonna place you under oath. You swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
All right, all right. Your name is Charles Harrison II, is that correct?
Yes, sir.
And Mr. Harrison, are you a United States citizen who reads, writes, speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you've read and signed today, that's part of your plea agreement?
Yes, sir, I do.
Do you have any questions before we go further?
No, sir. All well.
Mr. Manning, do you believe your client to be competent to enter into a plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after you've explained to him his legal rights?
I do, Judge.
All right, Mr. Harrison, you are charged by indictment with a first-degree felony offense of theft of property greater than $300,000. A first-degree felony carries a range of punishment if you were to be convicted and sentenced to not less than 5 years in prison or more than 99 years or life confinement in prison. You could also be fined up to $10,000. I see that there's a plea agreement in your case, and that's what you're asking the court to consider and approve today, is that right?
Yes, sir.
Understanding the plea agreement, understanding the range of punishment, Mr. Harrison, how do you plead to first-degree felony theft of property greater than $300,000?
Plead guilty, sir.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this crime?
No, sir, they haven't.
Right, court will accept the defendant's plea of guilt, takes judicial notice of his judicial confession, and the court admits the stipulated evidence in support of the plea. Anything further from the state? Anything further from the defense?
Just briefly, Judge, Mr. Harrison does have a out of county hold, so he will not be released immediately today. However, does have instructions to check on the probation department once he is released, and he will begin his probation at that point.
All right, thank you, Mr. Manning. Court's going to review the evidence. Do have a question about the plea agreement. Charge says theft greater than 300,000. Stipulated evidence says that he received over $500,000. And the plea agreement says restitution in the amount of 52,000.
That's correct, Judge. So the company made a claim on an insurance, and they were made whole by their insurance company. The $52,000 restitution is the not the copay, but I'm sorry, I'm blanking on the word.
I would help you if I could, but I'm not.
When you have an insurance claim and you have a deductible, that's right, the deductible. The $52,000 was a deductible owed by the company. And that's what Mr. Harrison is responsible for.
Mr. Hernandez, the state's not seeking to collect any restitution over the 52,000. Is that correct? That's my understanding. And the victim supports this plea? Yes. All right. And based on the evidence and the statements by counsel, court will follow the plea agreement. Court hereby finding that there's enough evidence to convict the defendant. Court convicts Charles Harrison II theft of property greater than $300,000. First degree felony. Assesses his punishment today at 10 years confinement, Texas Department of Criminal Justice Institutional Division. The court suspends the sentence, places the defendant on 10 years community supervision, orders him to pay restitution in the amount of $55,215.32 to Venture Metals in Wills Point, Texas. Court will order that restitution to be joint and several with Mr. James Murphy, cause number CR 2479. Court orders Mr. Hairston to pay court costs of $290 and reimbursement fees of $620. Mr. Hairston, you're hereby remanded to the custody of the sheriff and the probation department so they can carry out the terms and conditions of the sentence. Ms. Burns, are you going to be talking with Mr. Hairston to give him instructions on how to report once he's released from custody, wherever he's going?
Already have.
You already have, thank you. All right, thank you, Mr. Hairston. If you'll step over and be fair.
Yeah, thank you, sir.
And Judge, if I may have a moment, I can get some reset forms.
Yes, sir, go. Mr. Allen, you'll come forward. This is cause numbers CR 26-93, CR 24-253, CR 20. Actually, that's one. There's another one. That's. All right, Mr. Allen is here today for state's motion to revoke on unlawful possession of firearm by felon, and also a new charge. He's here for arraignment on theft of property greater than 2,500, less than $30,000. Go ahead, Mr.
Judge, at this time, I'm missing Isabel Rodriguez charges, and he's not guilty to C-6. Request that case be set for pretrial, as well as for show. So prepared for that.
All right, the court enters Mr. Allen's plea of not guilty into the record in cause number CR 26-93. Finds that he's waived the formal requirements of arraignment. Court sets Mr. Allen for pretrial hearing October 15th. And sets the motion to adjudicate on even date of October 15th. And the court will set motion to adjudicate on October 29th. For hearing. Who's next?
Judge, Mr. Douglas Hanson.
Mr. Hanson. All right, court calls cause number CR 26-97, State versus Douglas Eugene Hanson. Mr. Hanson's here on arraignment for unlawful possession of firearm by a felon.
Judge, Mr. Hanson's name is spelled correctly. He understands the charge against him, as well as the range of punishment. His plea is not guilty and request to be set on the pretrial docket to receive discovery and begin negotiations.
All right, court enters his plea as not guilty into the record, finds that he's waived the formal requirements of arraignment. The court sets Mr. Hanson for pretrial October 15th at 1:30.
Judge, I don't know if the state has tendered to you the motion to withdraw and amend on Mr. Meza.
No, sir.
Meza. Okay.
I have Blevins and Wagner.
Okay, Judge, we can go forward on Mr. Blevins.
Christopher Wayne Blevins, CR 25.
Yes.
What I don't have is the motion to withdraw, not just have an amendment.
That's Blevins. I'm the person.
Yes, yes, sir. All right, Mr. Blevins. State has filed a motion to withdraw its motion to adjudicate. They're indicating that they've reached an agreement with you that on the basis of that withdrawal, your probation will be, you'll continue on probation. You'll serve 91 days in the county jail as a condition. You'll receive credit for all 91 days served, and then you will be amended to include an additional payment of $500, which is for the attorney that was appointed to you in this matter. You'll raise your hand. I'm going to place you with oath. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
All right. All right, Mr. Blevins, is that your agreement and what you're asking the court to approve?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to make this agreement?
No.
Probation, are you in support of the state's recommendation? All right, court hereby grants the state's motion to withdraw its motion to adjudicate. Court amends the conditions of community supervision. Orders that Mr. Blevins serve 91 days in jail. Receives credit for 91 days of time already served. In addition, he is ordered to pay $500 in additional costs for attorney fees. Court is sounding the order on the state's motion. All right, thank you, Mr. Blevins.
Judge, you said you had Miss Wagner.
I've got the amendment. There's a motion. I don't have it. Tamar Lynn Wagner, CR 25258. Come on, Ms. Wagner, it's okay. It's okay. Do you have Ms. Wagner? Yes, please. All right, Ms. Wagner, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right. Ms. Wagner, you're here on the state's motion to adjudicate. They have filed a motion to withdraw their motion to adjudicate, indicating that they've reached an agreement with you. Based on that withdrawal, you're agreeing to amend your conditions of community supervision to include an extension of your probationary period for additional 1 year. And also as a condition that you would be attending the SAFE program, which is the substance abuse felony punishment facility as a condition. And that you would also be modifying your conditions to include an additional cost of $500 for attorney fees due to the filing of this motion. Is that your agreement and what you're asking the court to approve?
It is.
Do you have any questions about any of that?
No, sir.
Sure. If you have a question, now's the time to ask it.
I don't believe so.
Sure. Do you need to talk with Mr. Manning at all?
No.
No? Okay. Mr. Manning, do you believe your client's competent to enter into the agreement?
I do, Judge.
All right, Ms. Wagner, the court grants the state's motion to withdraw its motion to adjudicate. The court amends your conditions of community supervision, extends your period for an additional 1 year, orders you to attend SAFE as a condition, and orders you to pay an additional $500 for new attorney fees due to the filing of this motion. Thank you, Ms. Wagner.
Thank you.
Bernard, did I sign the conditions? I signed the motion. Did I sign the conditions on Levi's case?
Yes, sir.
I did, okay. Call if I did or not, sorry. Anyone else, Mr. Main?
Judge, I apologize. Did we say we had Mr. Maze's paperwork? Or are we still waiting on that? Okay. Uh, Mr. Sally,
Joel, Ryan, Sally, CR 26107. All right, Mr. Sally's here on arraignment for continuous violence against the family.
Judge, we are here on arraignment. My client's name is spelled correctly. He understands the charge against him as well as the range of punishment. His plea is not guilty. We request discovery and to be set on the pretrial docket.
All right, the court enters Mr. Sally's plea of not guilty into the record. Finds that he's waived the formal requirements of arraignment and court sets this matter for pretrial October 15th at 1:30.
Judge, I believe in looking at my docket, that's all that I have prepared at this moment. I know that while I've been up here, several of the plea paperwork packets have come through in order for me to go over those with my clients.
Do you anticipate some kind of disposition on this, Mr. Meza, so that we can prepare our end?
Yes, it's going to be a withdrawal and continue with safety as a condition of probation. And I believe they also are extending him a year.
So you won't. Okay.
Oh, I'm sorry, Judge. I was recently appointed to Mr. Cohey.
Paul Robert Cohey.
Yes, Judge.
All right, this is cause number CR 21-5. Paul Robert Cody on the state's motion to revoke. Go ahead, Mr. Mayor.
Judge, I was appointed this morning. I've spoken to the probation department regarding Mr. Cohey's violations and have a potential resolution I'd like to discuss with him. If we could reset it for that October 15th date.
Possible resolution for your continuance on probation, or is it time?
Judge, the probation's recommendation was safe P. I haven't had an opportunity because I was appointed this morning. I haven't had an opportunity to speak to Mr. Cohey as to whether or not he'd be willing to accept that. If you'd like to give me a few
Yeah,
moments.
in the interest of justice, let's do that. If he agrees to it, we can start that process today.
Yes, Judge.
Mr. Covey, have a seat. I'll call you back up in a moment. Mr. Mayor, he needs time to meet with you. why. Jeffrey Allen Smith, CR 24-176. All right, Mr. Smith, go ahead and have a seat. I believe that we're set today on the defendant's motion for evidentiary hearing. Any announcements, Mr. White?
Your Honor, we're ready.
All right. State, you ready to proceed? And if you'll turn your microphone on, please.
State's ready, Your Honor. We would ask the court to reconsider the state's motion to withdraw the motion to adjudicate guilt with the proposed modification to add an ankle monitor condition here that the court overruled on June 30th.
What's the basis for the reconsideration? There's something new.
Nothing new that I'm aware of. I believe the same conditions exist that existed then.
What's the state's argument as to why the court should reconsider its ruling?
We just believe that it's in the interest of justice to continue him on probation with the addition of an ankle monitor provision for a period of 1 year. The ankle monitor for a year, continue on probation as it currently exists, time-wise.
All right, the court denies your motion.
Very well.
May proceed.
State rests, Your Honor.
Benson,
State didn't produce any evidence, Your Honor. We're going to move for directed verdict. They're not true.
so Mr. Hall, the state produces no evidence.
That's correct, Your Honor.
So why did the state file a motion that it doesn't intend to proceed with?
At the time it was filed, it was anticipated that we would be proceeding through negotiation with defense counsel and further investigation. We determined that the appropriate resolution was to continue him on probation, but require him to have the ankle monitor. Since that was denied by the court, then it doesn't change our analysis of the facts.
What is the state's analysis of the facts?
That we believe it would result in the resolution that we just announced to the court.
What are the state's allegations in its motion to adjudicate?
Just a moment. Do you have it before you, Your Honor?
No, sir, I do not. But
Okay, it's,
I'm working as we speak.
count one alleges that he admitted to a polygraph examiner that he drank alcohol since being placed on probation. Count two alleges that on or about that same date of October 29th, 2025, he admitted to the polygraph examiner that he had left the state of Texas and traveled to Kentucky. Count three alleges that on or about the 9th day of December, he admitted to the polygraph examiner that he left the state of Texas and traveled to the state of Kentucky. Count four alleges that on or about October 29th, 2025, he admitted to the polygraph examiner of continuing to reside in his residence that is within 1,000 feet of a child safety zone. Count five alleges that on or about January 12th, 2026, he was unsuccessfully discharged from sex offender treatment by the treatment provider, John Motley, who is a master's level professional counselor.
So the state's abandoning all 5 counts?
That's what we anticipated doing with the motion to withdraw, Your Honor, and the agreement to modify the probation.
So these counts don't concern the state at all. It's your motion, but Mr. Smith is on probation, directed to follow certain terms and conditions. You believe that he did not comply with those conditions. File a motion, as you just read, of all these counts, various violations. You believe that it'd be in the best interest of justice and the community for Mr. Smith, who's charged with online solicitation of a minor, to be put back in the community after your allegations of drinking alcohol, leaving the state without permission multiple times, living within 1,000 feet of a child safety zone. That's your recommendation to the court is, well, actually, you don't have a recommendation. It's, you don't want to proceed, so you offer no evidence. So procedurally, it's just a dismissal and he's to be put back on that. But that is effectively what you're asking the court to do.
That's basically what it amounts to. We had hoped
That's
that
fine. That's fine.
we had hoped that we
That's fine,
would
Mr.
get
Hall.
the addition of
That's
the
Mr.
ankle
Mr.
monitor.
Hall, that's fine. That's fine. You said that's what you want to do. All right, the court finding that the state has failed to meet its burden. Court finds that the state presented no evidence on counts one, that the defendant violated his condition of community supervision on October 29th, 2025 by admitting to a polygraph examiner that he drank alcohol while on probation. Court finds the state has presented no evidence. Court finds count one to be not true. Court finds the state has not presented any evidence on count two that Mr. Smith has violated the terms and conditions of his community supervision by leaving the state of Texas, traveling to the state of Kentucky. Upon admission to the polygraph examiner, the court finds there being no evidence that count two is not true. Court finds that the state has failed to present any evidence on count three of its motion, alleging that on December 9th, 2025, Mr. Smith admitted to polygraph examiner that he left the state of Texas and traveled to the state of Kentucky, violation of the terms and conditions. Court finds there to be no evidence presented by the state. Court finds count three to be not true. Count four, then the defendant having been alleged to have violated his conditions by admitting to continuing to reside at his residence that is within 1,000 feet of a child safety zone. On admission to his polygraph examiner, court finds the state having presented no evidence, finds that count four is not true. On count five, court finds that the state has failed to produce any evidence whatsoever that the defendant was unsuccessfully discharged from his sex offender treatment provider, John Motley, on January 12th, 2026. Court finds count five is not true. Court having made those findings finds that the amended motion to adjudicate is denied. So effectively, Mr. Smith, state has not moved to terminate your community supervision. So it's my understanding that you would still be on community supervision. Correct, Mr. White?
Yes, sir. And I will instruct him to go over. Or proceed.
All right. Mr. Smith, I don't know what to tell you. You admitted that you violated terms and conditions of this court that I've put upon you, but apparently the order of the court's unenforceable today for you. So all I can do is tell you it's not in your best interest to continue to thumb your nose at the order of this court indefinitely. Do you understand what I'm saying?
Yes, sir.
Free to go.
All right, all I have for court today.
Thanks, Watch. Yeah, he's still on probation. That's what I just said.
What's that?
This one like that.
And then Mr. Ellis prior,
It's probation, you might have to check it, probation.
plus it's, not GC,
What time did you do it?
prior to this process.
Well, I got this product, well, I don't know when you did this project, when did you do it, like what time, like this afternoon?
Yeah, just, okay.
The only ones I received this afternoon were Charles Harrison, Justin Borg, Joshua Brown, times two, and April Proctor. I've done everybody but one.
The AOC on Mr. Ellis says maybe it didn't. Go. And good, speaking to probation department, visual institute, see. So, drawing.
Good job.
So they're looking.
Excellent, I appreciate that.
I just checked with her again, because I noticed we're just waiting on that one little thing.
That's good. All right, this is cause number CR 15-104, State of Texas versus April Lynn Proctor. Ms. Proctor, if you'll raise your hand, I'm gonna place you on the road. You swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth. So help you
Yes.
God.
Yes.
All right, thank you, Glory. All right, Ms. Proctor, you appeared before the court previously on February 24th of 2015. You pled guilty to unauthorized use of a vehicle, a state jail felony. Court heard the evidence. Court found that there was enough evidence to convict you. Court then followed a plea agreement that was given to you by the state. Court heard a finding of guilt, placed you on deferred community supervision for a period of 5 years. The court also assessed a $2,000 fine. It was during your period of supervision that the state filed its amended motion to adjudicate and revoke. They have alleged what appears to be 8 separate counts of violations. Have you had enough time to review that document and those allegations with your attorney, Mr. Manning?
Yes.
Are you pleased with Mr. Manning as your attorney?
Yes.
Do you have any questions about anything that you've read and signed today? Mr. Manning, do you believe your client to be competent to enter into a plea agreement? And if so, that she's waiving the formal reading of the state's amended motion, does she intend to plead true to all counts?
Judge, she is competent. She does intend to plead true to all counts, and I believe she's doing those things intentionally, knowingly, and voluntarily.
All right, Ms. Proctor, how do you plead to counts 1 through 8? Are those counts true or not true?
True.
And are you telling me that each one of those counts are true because what's alleged in there is in fact true and you committed those violations?
Yes.
Has anyone threatened you, forced you, or pressured you to plead true to any counts?
No.
The court does accept the defendant's plea of true. Court admits into evidence the defendant's waiver of the waiver rights of plea of true. Anything further from state?
No, Your Honor.
From the defense?
Rest in close, Judge.
All right, and Ms. Proctor, based on the evidence before the court finds that you have violated the terms and conditions of your community supervision. Court finds counts 1 through 8 to be true. Court hereby adjudicates your guilt, convicts you of the offense of unauthorized use of a vehicle, which is a state jail felony. Court assesses your punishment under section 1244A at 254 days in the Van Dant County Jail. Court gives you credit for all 254 days of time already served. Court ordered you to pay the balance of your financial obligations. Once you are released from custody, Ms. Proctor, you're still responsible for the fines, court costs, and fees that were previously assessed. Your failure to make arrangements to pay for those could result in a warrant being issued for your arrest. So what I would order you to do upon release is to appear here at the Van Zandt County District Clerk's office across the hall and let them know who you are and that you need to make payment arrangements so that you can avoid being rearrested on this cost. Do you understand?
Yes, Judge.
All right, Ms. Proctor, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to me. Donald Ellis. All right, this is cause number CR 24-83, State of Texas versus Donald Allen Ellis. Mr. Ellis, if you'll raise your hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. All right, Mr. Ellis, you have been in this court previously. And on November 12th of 2024, you appeared and pled guilty to a second-degree felony offense of arson. The court found that there was enough evidence to convict you. However, the court deferred a finding of guilt and placed you on community supervision for a period of 10 years based on the plea agreement that you reached with the DA's office. It was during your during your period of community supervision that the state has now filed a violation and indicated that there are 8 separate counts of violations. Have you had an opportunity to review those allegations with your attorney, Mr. Jonathan Manning?
Yes, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you've read and signed today?
Yes, sir.
Do you have any questions?
No, sir.
Mr. Manning, do you believe Mr. Ellis to be competent to enter into the agreement, and if so, that he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights?
I do.
All right, then, Mr. Ellis, how do you plead to counts 1 through 8? Are those counts true or not true?
True.
And has anyone threatened you, forced you, or pressured you to plead true to those 8 counts?
No, sir.
All right, court accepts the defendant's plea of true to each count as alleged, takes judicial notice of the defendant's judicial confession. Anything further from the state? No, Your Honor. From the defense?
Judge, just that Mr. Ellis has 183 days credit.
183?
That's correct, Judge.
Thank you. All right, Mr. Ellis, based on your judicial confession and the evidence before the court finds that you have violated the terms and conditions of your community supervision. Court hereby adjudicates your guilt, convicts you of the offense of arson, revokes your community supervision, and assesses your punishment at 6 years confinement. Texas Department of Justice orders you to pay the balance of your financial obligations, and the court awards you 183 days credit towards your sentence for the time that you've spent in jail on this cause. Once you're released from TDC, if you've not made arrangements to pay off what you owe, when you come out of TDC, that doesn't wipe your slate clean as far as costs. Okay, so failure to pay those things could result in being rearrested. Okay, so when you get out of TDC, come up here, make arrangements, and the county will work with you to keep you out of jail. Okay.
Yes, sir.
All right, you're hereby remanded to the custody of the sheriff. If you'll go see Sergeant Martinez, he's going to take your finger.
Thank you.
All right, who's next, Mr.
Judge, Mr. Meza, I believe paperwork is completed on him.
Mr. Meza? Yes, sir. Dylan Meza? This is call number CR 19147, State of Texas versus Dylan Ray Meza. Mr. Meza, if you'll raise your hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, Your Honor.
Thank you, sir. All right, Mr. Meza, the state has filed a motion to adjudicate your guilt previously. However, it appears that today there's an agreement between you and the state wherein the state is tendering a motion to withdraw, indicating that the agreement is that you're agreeable to continuing your community supervision, that you're continuing to stay on community supervision, extend that period for an additional 1 year, and that you would attend the rehab substance abuse felony punishment facility as a condition of community supervision. And you would also be obligated to pay an additional $500 in your community supervision based on the motion to adjudicate. Is that your agreement here today?
And Judge, if I may, two slight corrections. Mr. Meza is retained. And so I don't believe there's a.
Then y'all fix this.
Okay. And additionally, Judge, he's, Ms. Burns let me know that because he's on for 10 years, he's released.
Fix that. Go ahead and have a seat, Mr. Mason. I'll call you back up.
All right. So there were two corrections.
Except,
So there's no fees and no extension.
no court fees,
No,
Court
no
costs?
attorney fees,
fix that,
and there's no extension.
right?
Mr. Mason, you'll come back up. Service. I'll have to ask the coach. All right, Mr. Mason, we're back on record in cause number CR 19147, State of Texas versus Dylan Ray Meza. All right, Mr. Meza, I think there's been some corrections. You're still under oath. Do you understand that?
Yes, Your Honor.
Okay. So there's been some corrections to the plea agreement that was submitted to the court. It appears that on the state's motion to adjudicate, that they filed a motion to withdraw, and the agreement appears to be upon that withdrawal, your agreement is to continue on community supervision with the state's approval, and also that you would amend your conditions and add an additional condition that you would go to safety, the rehab punishment facility, correct?
Yes, Your Honor.
All right, Mr. Meza, has anyone threatened you, forced you, or pressured you to make that agreement to amend your conditions to include rehab?
No, Your Honor.
All right, and in this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you?
Absolutely, Your Honor.
Do you have any questions about anything? Now's the time to ask if you do.
No, Your Honor.
You sure? You hesitated. Whatever the question is, ask Mr. Manning, and if it's something we need to address, we're happy to address it.
Nothing about our conditions, Your Honor.
Sure?
Judge Mason.
Go ahead, Mr. Manning. Any follow-up, Mr. Manning?
No, Judge. Mr. Meza has two young kids that are out waiting his return, and so he is ready to put this period in his life behind him and get on being a good father. I've had several people reach out to me and contact me regarding how far Mr. Meza has come in his life and overcoming some very difficult circumstances to be a good father. And so I think it's just the emotion of realizing that he still has 6 to 9 months before he'll get to see his kids' faces again.
Is that true, Mr. Mason? Understand. I know it's very difficult. I couldn't imagine being away from my kids for that amount of time, but Mr. Meza, you're here today because you're admitting you have a drug problem, right? Is that right?
Yes, Your Honor.
And in order for your kids to have the best father possible, you can't have that in your life. Do you agree?
Yes, Your Honor.
It's not good for them. It's not in their best interest. Okay. So I know that 6 to 9 months is a long time, but having a lifetime after that with your kids and not having to worry about going back to prison because you're having to battle a drug addiction that you never got help with, I think it's a great trade. I understand. How old are your kids right now?
My son will be 5 soon, and my daughter will be 1.
How old was the first one?
He's 4 right now. He'll be 5 soon.
I can tell you from experience, all right, that children are that young, their memories, they might not even know that you're gone. Day to day, they're going to know you're gone. But for that period, when they get older, they might not even remember that. So what a great opportunity it is today for you to go and get help and resources so that you can get this drug addiction out of your life, that you'll have the tools to be able to fight it. Something that you'll have to fight the rest of your life, but it's better to go now and be equipped than have to do this when your kids are 10, 12, or 16, when they would remember. Okay. So the only reason I tell you that is because I know it's difficult, but I want to give you something positive to think about. They're not going to remember dad's not there. Okay. And when you get older and they get older and they're old enough to understand, you can tell them, hey, I went and did what I did when you were younger so that I could be here for when you're older. They're going to appreciate that a lot more. Okay. So the fact that you're emotional about separating from your kids gives me confidence that when you go down to this rehab, that you're going to be ultra focused on doing what you need to do to get the help that you need so that you can get out of there and get back. A lot of people go to safety And for me, it's just a coin toss. I don't know if they're serious or not. Sometimes it's avoid prison, sometimes it's to get away from family and various other reasons. So for you, I feel confident that yours is because you really want to get this behind you and do the right thing. I remember we've had several conversations when you were in sanctions court, right?
Yes, sir.
We've worked through this. And I remember you talking about your kids and those issues. So I've always known you to be a sincere individual. Okay. So, and you're young. How old are you? Remind me.
26 now.
26. You're a very, very young man. And so hopefully you got a lot of life ahead of you, and your life span will be longer and better when you don't have methamphetamine or whatever it is that is your drug of choice in your life. Okay.
Yes, Your Honor.
So I'm gonna grant the state's motion to withdraw its motion to adjudicate. And I'm gonna order your conditions to be amended. And sometimes people say good luck. When you go to safety, it's not about luck. It's about work. Okay, it's about being intentional. Go down there, be intentional about the work, be intentional about what you can learn, and learn as much as you can, and then come out, because you're gonna need that. There's gonna be days when you're gonna need that support, be able to fall back on that training and that knowledge so that you can stay out of this court and be with your family. Okay?
Yes, Your Honor.
All right. All right, Mr. Meza, we'll pray for you. All right, Mr. Manning, you need time or you have?
No, Judge, I'm ready for Mr. Coe. My understanding is the probation has his paperwork.
I also have Joshua's seal right, but I think that's. Mr. Hernandez, do you have a motion to withdraw, Mr. Cody? I have not received. Just a motion to withdraw the motion to adjudicate. Is that the one that you usually print out?
Then I've been getting it from the office.
Oh, you have, okay.
I said that.
Oh, that's okay. Before we bring him up, just tell me what it is and then we'll go ahead and do it.
Yes, Judge. It's going to be withdraw and continue with safety as a condition of probation, $500. And I don't remember if we're extending him or not. If I may just have a moment.
Sure.
How long the term of the probation?
There will be an extension of double check. Yes, there will be an extension of 1 year for his probation.
All right, court is on record in cause number CR 2152, State of Texas versus Paul Robert Covey. Mr. Covey, you'll raise your hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. All right, Mr. Cody, you are here on the state's motion to revoke. The state has tendered or will be tendering a motion to withdraw its motion to adjudicate or revoke based on an agreement wherein on that withdrawal, you're agreeing to attend the substance abuse felony punishment facility rehab as a condition. You're gonna amend your conditions and add an additional $500 for the attorney fee that's been incurred based on this motion, and you're agreeing to extend for an additional 1 year. Is that correct?
Yes.
Mr. Cohey, has anyone threatened you, forced you, or pressured you to make that agreement?
No, sir.
All right, Mr. Manning, do you believe Mr. Cohey to be competent to enter into the agreement?
I do, Judge.
All right, then the court grants the state's motion to withdraw its motion to revoke. Court amends the conditions of community supervision to include safety, additional $500 in attorney fees. The court extends the supervision period for an additional 1 year. Once the state's motion is filed, we'll sign that. All right, Mr. Cohey. So you are also going to safety, is that right?
Yes.
What are your hopes for rehab?
To put my drug use behind me. It's ruined my life. It's ruined my family's life. I need help to get by it.
How long have you been struggling with drugs?
Since I was a teenager.
How old are you now?
Excuse me.
How old are you now?
I'm 43.
43, and you've been dealing with it for what, 30 years?
Yeah. I've had I went to the VA's rehab program and I had quite a bit of clean time on me, but I relapsed and there's no excuse for it. I got to put this behind me. I need the help.
Well, I appreciate you admitting that. I'll tell you the same thing I told Mr. Mesa. Have high hopes for you to go down there and just put in the work, do the best that you can to figure out how it is to, make better decisions on friends, locations, circumstances, how to deal with anxiety, grief, stress. Because I think you already said it. You said it's ruining your life, and you recognize that, don't you?
Yeah.
Have you had any bouts or spells of your life where you've been clean and you've not been on drugs?
4 years, the 4 years I was in service.
Do you wish that your life today was as good as it was those 4 years?
Yes, I do.
It can be, right?
Yes,
Can be. Do you believe it can be?
I believe it can be.
Good. And it's not going to be out of luck or just because it happens. It's going to be because you make it that way, right?
Right.
All right. Well, we'll pray for you too, Mr. Cody.
Thank you.
Granted that, we'll see you. Hopefully, I don't want to say see you soon because I don't want to see you soon, right?
Yes.
I just want to hear, the next thing I want to see is Miss Burns bringing me a piece of paper that says, hey, Mr. Cody's done all of his conditions and we want to let him off probation. That's what I hope for you, okay?
Okay, thank you, sir.
Thanks. Man.
Judge Mr. Modlin.
Duncan Barry Modlin, CR 2660. Mr. Modlin, just go down that second row, is fine. All right, Mr. Modlin's here on pretrial.
Judge, the discovery in this case is rather extensive, and I've been unable to go through all of that with Mr. Marlin. I'd request one additional pretrial so that we can accurately discuss the allegations and prepare our defenses.
Any objections from the state?
Yes, sir.
All right, court sets Mr. Marlin for pretrial October 15th. And Mr. Manning, due to the length of the reset, what I would like to do is if we can make an announcement on if there are no contested pretrial issues, assuming that fact, what I would like to do, if there are no issues, is go ahead and begin the plea negotiation process to determine if there's going to be offers or anything made. I know that we're working on a shortened timeline, so I'd like to get as much done on Mr. Marlin's case as possible.
Yes, Judge.
Thank you.
The last one I have ready right now is Mr. Tolliver.
Marcus Lynn Tolliver, CR 25139. Mr. Tolliver here is today on final docket.
Yes, Judge. Given that we are on final docket call, I would like to make a short record. I have requested offers for Mr. Tolliver 3 separate occasions. I understand the state doesn't have to offer Mr. Tolliver anything. However, we have requested on June 16th, August 12th, and as recently as August 25th, a request for offer. Additionally, we've also produced a proposed offer for Mr. Tolliver to plead to, and I have not heard a response to that recommendation. The reason I want to be very clear is there's been no offer for Mr. Tolliver to reject, and so if the state has an offer, we would gladly consider that. As I said, Mr. Tolliver has requested a resolution, and we've proposed that in those emails. With that, I would say that we are not ready to proceed to jury selection, but I do understand we are at final docket call today.
Response from state.
And I understand that, my apologies, I've been responsive to those requests. I just had a brief extension of time. Top of the list to make sure that we extend an offer for him. for us to have a conversation.
What I'm gonna do is I'll grant the request, Mr. Hernandez, but I'm gonna go ahead and place him on docket call. And then y'all go ahead and engage in plea negotiations, and if you can reach one, based on the offer that's made by the 15th, then you can notify the court and we set it for the court to consider. And if whatever offer they make, if it's not accepted by the defense, then Mr. Oliver will already be on the jury selection.
Okay, so you want him placed on the jury selection docket? But the date we will give is October 15th.
Yes.
Okay.
It stays October 15th to make an offer. If that offer is accepted, or if there's more plea negotiation based on that offer, then if counsel will want to notify the court, we can set it for the plea, the court will set it. So I'll just place Mr. Tolliver on the court's rolling trial docket for this time. We'll begin at October 5th.
Yes, Judge.
If y'all resolve it, if you want to resolve it prior to then, just notify the court.
Judge, that's all I have right now. If I may have a moment to finish up paperwork.
Yes. All right, court's gonna stand in recess, I'm sorry.
No. Don't do it.
Mr. Seal. All right, Mr. Seal. You'll raise your hand on the place under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. Your name is Joshua Lee Seal, is that correct?
Yes, sir.
And Mr. Seal, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done?
Yes, sir.
Do you have any questions about anything that you have read and signed today?
No, sir.
Mr. Schmidt, do you believe Mr. Seal to be competent to enter into a plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after you've explained his rights to him?
Yes.
All right, Mr. Seal, you are charged by indictment with a second-degree felony offense of evading arrest or detention with a vehicle that does carry a range of. Is there an enhancement on this?
States. Paragraph, it's a second degree felony.
Okay, thank you. All right, so Mr. Seal, you've been charged with a third-degree felony offense of evading arrest or detention with a vehicle that would typically carry a range of punishment of not less than 2 years or more than 10 years in prison. However, the state has sought an enhancement onto your sentence, elevating it to a second-degree felony, which increases the range of punishment to not less than 2 years or more than 20 years in prison, and a possible fine not to exceed $10,000. You have reached a plea agreement with the state, is that correct?
Yes, sir.
Do you understand it?
Yes, sir.
You're asking the court to approve.
Yes, sir.
All right, at this time, how do you plead to evading arrest or detention with a vehicle?
Guilty.
How do you plead to the enhancement paragraph alleged in the indictment? Is that enhancement allegation of your prior conviction true or not true?
True.
The court will note that the state has abandoned the second enhancement paragraph allegation. All right, and Mr. Seal, has anyone threatened you, forced you, or pressured you to plead guilty to the primary offense or true to the enhancement allegations?
No, sir.
All right, the court will accept the defendant's plea of guilt and plea of true. Court also admits in evidence the stipulated evidence, takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court's reviewing the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement and recommendation. Mr. Seal, you hereby convicted of evading arrest or detention with a vehicle. Court finds the enhancement paragraph to be true. Court assesses your punishment as a second-degree felony at 15 years. 15 years confinement in the Texas Department of Criminal Justice Institutional Division, assesses a $3,000 fine, $180 of restitution, and the court dismisses under section 1245. Well, the court can't dismiss. The court will take into consideration under section 1245, FC 2649, possession of controlled substance less than 1 gram. I believe that dismissal will have to be filed in the county court of law with Judge Winters. Furthermore, the court assesses restitution of $180, court cost of $290, and reimbursement fees of $20. Mr. Seal is awarded credit time, court's his sentence for the amount of time he has spent in jail on this case. How many days, Mr. Schmidt? 130. Court awards 130-day sentence, 130 days of 130 days time credit towards his sentence as cause. Mr. Seal, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. All right, court's going to stand in recess and give Mr. Manning time to speak with the funds. Mr. Looney. All right, court is on record in cause number CR 26-1, State of Texas versus Keith Edward Looney. And also CR 26-20. Mr. Looney, if you'll raise your hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So,
Yes, sir. Yes, sir.
all right, over here. Your name is Keith Edward Looney, is that correct?
Yes, sir.
And Mr. Looney, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney?
Yes, sir.
Understand everything that you have read and signed, that's part of your plea agreement.
Yes, sir.
You have any questions about anything before we go further?
No, sir.
All right, Mr. Manning, do you believe your client to be competent to enter into a plea agreement, and if so, that he's doing it intentionally, knowingly, and voluntarily after you've explained his legal rights?
Yes, Judge.
All right, Mr. Looney, in cause number CR 26-20, you are charged by indictment with a state jail felony offense of theft of property greater than or equal to $2,500 and less than $30,000. That does carry a range of punishment of not less than 6 months in prison, nor more than 2 years in prison, and you could also be fined up to $10,000. I see that there is a plea agreement in your case. You've read that plea agreement, and that's what you're asking the court to approve.
Yes, sir.
All right, Mr. Looney, how do you plead to theft of property greater than $2,500, less than $30,000?
Guilty.
You pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt, takes judicial notice of his judicial confession. The court admits the stipulated evidence in support of the plea. Anything further, Mr. Manning?
Judge, I believe it's also, the assault has been filed regarding CR 26-1. Ask that you also dispose of that case. Take care of all the things here in Manhattan. Additionally, Judge Shaloni has 200 days credit from when the warrant was served on him. I talked to Mr. Looney, he said that he was in custody in Smith County. But we were unable to, they were unable to verify a whole thing. That's in Smith County while Mr. Looney was in custody.
Court does note that the state has filed a motion to dismiss cause number CR 26-000. All right, court's going to review the evidence at this time. All right, we're having reviewed the evidence, find enough evidence to convict the defendant of the offense. Here's the stipulation of evidence as a different cause number than all the other documents. Stipulation of evidence is in cause number CR 26-1.
Judge, CR 26-1 is the maybe they
Don't have a stipulation of evidence in cause number CR 26-20 to which he's pleading to. One and the same.
may have both. CR 26-1 is.
I'm saying that the stipulation of evidence goes to the dismiss case, not to the plea case. Okay. This is what it says. Tell me if it's one and the same. It says on May 5th, 2026, there was a burglary at 7754 at 858 in Wheeler, Texas. On May 28th, 2026, I was in possession of several items from that burglary. Knew that the items were stolen. The items had a value of at least $2,500, but less than $30,000. That bears cause number CR 26-1. Is it the same stipulation of evidence?
That is the stipulation for CR 26.
20? Okay. All right, then. The court will note for the record, based on the statement of counsel, that the stipulation of evidence admitted in the plea packet is the same stipulated evidence for cause number CR 26-20. All right, upon reviewing the evidence, the court finds that there is enough evidence to convict the defendant of the offense. Court follows the plea agreement. Court convicts the defendant of the lesser included offense of theft greater than $2,500, less than $30,000. Assesses punishment at 2 years confinement. Texas Department of Criminal Justice, State Jail Division orders the defendant to pay $1,000 fine, $290 in court costs, $105 reimbursement. Furthermore, the court awards Mr. Looney 294 days credit towards his sentence for the time that he has spent in his cause. The court notes for the record that there was no restitution claimed or sought on this further. All right, Mr. Looney, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you join Sergeant Martinez to be fingered.
Sir.
Go ahead, step over the.
Okay, thank you, Don.
You're welcome.
Judge, I believe we have hearings on the writs for both Mr. Fields and Mr. Langarica.
Did we already do Mr. Blevins?
Yes, Judge.
Bled Mr. Blevins out?
It was reinstate with 91 days.
Okay. Sorry, I just did fumble it all. Right.
Would you like them at council table?
Yes, let me call him up. Mr. Fields. Sergeant Martinez, I'm going to have Mr. Fields up here. Get that microphone up.
Judge,
I want multiple.
okay.
All right, court is on record in WR 26-19. Edward Fields versus State of Texas. What, Mr. King?
Yes, Judge. I filed a writ on Mr. Fields last week when his 90 days was up. At this time, he is unindicted and has been in custody for 99 days. We would request that he be given PR bonds. Mr. Fields is unable to afford any type of bond at this time. And he additionally, Judge, has holds out of Dallas County of no bond holds for 3 counts. And so he will not be released today, but will be transported to Dallas County.
He understands that if he granted a PR bond, he will not be accruing any credit towards his charge based on the it him being non-released in since Dallas County.
Judge, I don't believe I specifically discussed that with him, but I can explain that to him.
Think you'd wanna know.
Judge, he understands.
And he elects to move forward and request a personal bond.
Yes, Judge.
Anything from the state? All right, court finds that Mr. Fields has been continuously confined for more than 90 days on the charge of arson, intent to damage a habitation or place of worship that the state of Texas has not returned an indictment, and therefore Mr. Fields is entitled, because of that failure, to be released to the community on a bond that he made, or a personal bond. Mr. Manning, can I hear testimony on whether or not he has the ability to make a bond? That you says a bond that he can make, or a personal?
Yes, Judge.
Find out if he has any assets or ability to make a bond at all.
Yes, Judge.
Mr. Fields, if you'll raise your hand, place your oath. Sir, do you swear that the testimony you give to the court, the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right. Go ahead, just make sure you speak up loudly and clearly, because I've got.
Yes.
Mr. Fields, do you own a home?
No, sir,
Do you own any real property?
No, sir.
Do you own any personal property of the nature that you can sell in order to make a bond?
No.
Do you have anybody who can assist you in making a bond on this case?
No.
Do you have a home or somewhere to stay if you were released from?
Yes, I do.
Okay, and where is that located?
Maybank.
Okay. Have you tried to get with family or friends on the outside in order to make a bond in this case?
Yes.
And during the 99 days, have you guys been able to reach
No.
an agreement to make any type of
No.
bond? Okay.
Any questions from the state?
Oh,
Any further, Mr. Manning?
No, Judge, we'd ask that under 17-151, he be granted a PR bond in this case, as he has been found indigent by this court and been in custody for more than 90 days.
All right, the court hereby grants writ, finds that the state has agreed to an order regarding bail. Court sets personal bond in the amount of $100,000. Court has signed the agreed order regarding bail.
I transferred it down, so.
Longarika? On record in writ WR 26-0022, Enrique Longarika Jr. versus Texas. Raise your right. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Go ahead, Mr. Manning.
Yes, Judge. I filed my writ on behalf of my client. He is now at 97 days since his incarceration on May 21st, 2026. At this time, he has not been indicted or information has not been filed. If you would like, I can make a record of his financial situation regarding his ability to make bond. Mr. Langarica, do you own a home?
No, sir.
Okay, and do you own any real property or personal property you can use to make any type of bond?
No, sir.
Okay. Have you any family or friends who can assist you in making a bond?
No, sir.
In fact, most of your family lives where?
Arizona and California.
Okay. Have you attempted to make a bond in this case?
What do you mean?
Have you contacted a bondsman? or-
No, sir.
Okay. Do you have any vehicles or anything you can sell in order to make this bond?
No, sir.
Okay. As a matter of fact, your vehicle that you did possess, is out of commission. Is that correct?
Yes, sir.
Okay. Do you have a bank account?
Yes, sir.
And does it have any money in it at last check?
It was -70, sir.
Your Honor, pass the witness.
Any questions from the state?
No questions, Your Honor.
Any further, Mr. Manning?
Judge, we'd ask the court to take judicial notice of the finding of indigence made by this court, as well as the fact that it's been 97 days and my client has not been indicted or had information filed on his case.
Does your client understand that he's gonna be under conditions of pretrial release that prevent him from having any contact with the alleged victim and the felony aggravated assault and misdemeanor violation of bond protected order?
Yes, Judge, I've explained to him the conditions of bond and explained to him that any violation of those conditions of bond will result in revoking of his bond and new charges being filed.
Does he intend to go back to the same residence that this alleged victim is located at?
No, Judge.
By the court finding that the defendant has been arrested for aggravated assault and violation of bond and protective order, finds that he's been continuously fined more than 90 days. State has failed to indict the defendant or otherwise formally charge the defendant. Therefore, the law entitles him to be released on bond that he can pay or a personal bond, or finds that the state has agreed to release him on recommended bond of $100,000 felony aggravated assault, $5,000 on the violation of bond. Each one of those are going to be conditioned on court's conditions of pretrial release. Defendant is ordered not to have contact at all whatsoever with the alleged victim in both cases. If they're different victims, then there will be no contact with either. It's the same victim, no contact.
Yes, sir.
Understand?
Yes, sir.
All right, the court has signed the agreed order regarding bail.
So.
Bill, you need us? I'll give him 5 minutes. What's?
Thank you. He was getting standard. You're putting him on. Right.
That's right. Yeah, I said I want no contact.
You can text that.
Not just 30.
So emails are done. Emails aren't. But if you change.
Yep.
I need him, Donna.
Officer Langridge, go ahead and have a seat. She's gonna come over here and go over the conditions of pretrial release. It's okay.
Business.
Yes. All right, I believe that would conclude the court's criminal docket. We are adjourned.